Hey, good afternoon, live. John Fountain, Joel VanderVeur. How you doing, guys?
Fantastic. Thank you, Mike.
Doing great.
Well, ladies and gentlemen, my name is Mike Price. Thank you for coming today. The topic of our interview today with Joel VanderVeur is commissions update. So what? Now what? So John and I have been talking about this for a while, and we just want to make sure that as agents, we're looking at this through the lens of an agent, but also what does that mean for the consumer? And so we brought in Joel VanderVeur with Pacific Law, who's been really following this case and actually reading the cases and memorizing these cases. And he's going to tell us a lot of information about what's really going on, not what you're hearing on the news, and how we can use that not only to talk to our clients, but to how are we going to navigate in this new world we're going to be in here in a couple months. So a little bit about Joel. Joel went to law school in Boston, and he got into in 2011. He worked for the district attorney's office in DeKalb County, and then in 2012, Joel moved into real estate law and started working for some big real estate companies in town. And a fun fact: Joel helped roll out 5G in the United States. So if anybody has 5G on the phone, you can thank this man right here. He was part of it. And in 2012, after he moved to the big companies, 2023, he joined Pacific Law, where he is right now with Mr. Justin Pacific. So, Joel, we really appreciate you coming today and sharing all this information with us. And John, tell us a little bit about what we're getting into today.
Yeah. So, well, first of all, Mike, thanks for having me. Joel, really honored to be on the call with you. And, I think it's important just to kind of give some context around why Mike and I decided we wanted to host this on the StreamYard, but almost like a fireside chat, right? We just wanted to get together and talk about what's going on with these commission updates. I mean, there's so much misinformation in the market right now from, I think certainly buyers and sellers around what's going on with these headlines, but also just in the agent community. I've talked to so many people that are, on one end of the spectrum, super nervous about what's coming because they probably don't have the right information. And then I've talked to some agents that are like, man, nothing's going to change. It's all going to work out. And honestly, don't know who's right. Mm-hmm. I mean, it's a, who knows? Like, we'll see. I think it's going to be a little messy for a little while. And I think eventually, the industry will figure out how to adapt. But today we just wanted to get together and ask our friend Joel, hey man, what do you know about this? Give us some context, give us the facts, and then what should we expect? And, Mike, if it's all right with you, we'll just kind of make this like a little podcast format where, we're asking Joel some questions and having fun.
Absolutely. And then we'll, of course, open it up to everyone out there who's watching, so we can get some feedback. So, yeah, absolutely.
Yeah,
Sounds great.
And by the way, I got to give a plug out to Homeward. If anybody needs to buy and sell, at the same time, let me know. You reach out. I'd be happy to help. So
buy before you sell.
Buy before you sell.
Before you list.
And sell before you list. Either one. If you have no clue what we're talking about, it's a good reason to let me know. Just reach out.
And if anybody has never done work with John Fountain at Homeward, I can tell you right now, if you're looking for another option for your client that's selling and wanting to buy, and turn them into a cash offer, John's your guy. We've used him multiple times. It's been a home run every time. So, John, I appreciate you doing that.
Thank you, Mike. And y'all, on that note too, if you don't know Joel with Pacific Law, then you've got to reach out to him as well. He is amazing. He's the managing partner out of Joel, you're the Alpharetta office, right?
Alpharetta, yeah. Mm-hmm.
Yeah. So, okay. So, and Mike, that leads me to how this conversation started with Joel. You went to an amazing lunch with him. Gosh, probably 2 months ago now, right?
Yeah.
And Mike called me, Joel, right after the lunch and was like, oh my God, I just had the best lunch with this new attorney that I've met. And we were talking about commission updates and what's going on. And he's a wealth of knowledge. And so that's really why we, wanted to do this today. But Joel, why don't we kick it off? How did we end up here? Like what's going on? Give us some context. Context without or text without context is meaningless, right? So how did we end up here?
Right. Well, I guess I can't start the conversation without pointing out some of the headlines that, of course, consumers, buyers, sellers are reading and are bringing
Yeah.
up to their agents. Mike, I know you're encountering this yourself. John, you are as well. So there's a CNN article that came out shortly after this that says the 6% commission of buying and selling a home is gone after the Realtors Association agrees to seismic settlement. Another headline says NAR settlement could change the way you buy and sell your home.
Yeah.
You can't help as a consumer. And of course, you turn on any news channel right after the decision came out, and you're hearing this. Whenever any new settlement comes out, you're hearing it. The consumers are hearing it.
I was on a call yesterday. In fact, Mike, I think I shared this with you, but I was on a call yesterday where I was with another agent and we were explaining Homeward, and the seller literally goes, "Hey, commissions are flat rate now, right?"
Right. Yep. That's another one. Yes. Or another one. Seller no longer has to pay the buyer's agent, right? Like it was a requirement to begin with.
Correct.
And see, I think this is that misinformation, the lack of detail that has been disseminated to the clients, the buyers and sellers, and they're running with it. So, in talking to Mike a couple months ago when we initially sat down for lunch, and I don't even know how, Mike, we got onto the conversation. Somehow, these things just kind of come up. I mean, of course, it's in the news, but
it's the hot topic.
It's
sure.
a hot topic, right? Yeah. And for me, I've been speaking on this since last year, almost immediately after the case decision came out, because I knew that this was going to be something that will change the industry. Now, not listening to the headlines, because that's not what's happening, but for my clients, agents, loan officers, lenders, brokers, there is meaningful change here. And now we've seen going into this year, the number of settlements and primarily the National Association of Realtors settlement is changing the landscape in a manner that everybody who's in this industry needs to know. So as far as these myths, we will get into them as to why that they're not. They're not accurate. When we discuss the case and the terms and the actual settlements, we'll see that these what the clients are hearing from the news media, they're just surface level. But nonetheless, you as an agent need to know how to respond to these comments, because you will and are going to be receiving them.
Well, and at the end of the day, right, tell me if I'm wrong, but it's always been a choice, specifically in Georgia, where all three of us are. It's always been a choice for a seller to pay a buyer's agent a commission, right? And commissions have always been negotiable. And at the end of the day, that part is not changing.
That's correct.
Yeah.
Now, there is some nuance to that argument, though. And this is why I think it's important for us to have this conversation. And I will get into that nuance.
Exactly. How do I stay out of, real estate jail, right?
Mm-hmm. You got it.
So we'll get into it. Tell us about the settlement. Tell me about the cases. Give us the background that I know you've done extensive research on.
Yes. Well, thank you. Yes, I think it has to start. Well, just a brief history, very brief. Buyer agency started in the late 1800s, about 1870s and 80s, around there. So with that, the advent of the National Association of Realtors, they were called National Association of Real Estate Exchanges, was in 1908. So that's kind of where it got started. Well, after that time, in 1950, there was a case that went up to the United States Supreme Court. And that case was about price fixing, primarily in Washington. The fixing of commissions, as being a member of the National Association of Realtors at the time, the NAR had a recommended price commission structure. And so the Washington board accepted it, implemented it, and the suit did go against the Washington Realtors. NAR was actually exempt from that. But what it did was it did set the tone from going forward of commissions always being negotiable. So it's important to know that for the almost 100 years, the commissions have been negotiable, and the clients need to know that. So, but the standard up until the 90s was essentially listing broker. The listing agent had the deal, had the property to sell. When a buyer came unrepresented, sometimes the listing broker would have a sub-agent appointed if the buyer needed assistance that did not represent the buyer, was not a fiduciary for the buyer. But that was kind of the working structure at that time. Well, what you can imagine when buyers are buying homes unrepresented, things can happen. Buyers can feel like they were like there was they were not treated fairly in a transaction, and lawsuits came about. A lot of lawsuits came about.
Yeah.
And so in the 90s, brokers taking the lead and National Association of Realtors taking the lead decided to create a bundled or cooperative payment structure to, in essence, under the MLS structure, have a sharing of commission. It wasn't increasing commission, right? The sellers were still paying the normal commission rates that were normal. I mean, what was just part of the practice in a given jurisdiction. The listing side decided, you know what, we want to help buyers. And by doing that, they created this cooperative commission structure where a listing broker, when posting on an MLS, will decide, hey, we want to share our commission with the buyer's broker. So that way a buyer can be represented. So that was arguably a very good thing, right? I mean, we want buyers to have representation. We want to lower the number of lawsuits. And we definitely saw that. We saw a reduction in the number of lawsuits because buyers were represented. And it's like
I got to pause there. You know, there are some, we can talk about this in a moment, but there are definitely some companies that believe buyer's agency, and they're promoting, this is maybe one of those myth understandings that we're talking about, right, that buyer's agency is going away. There's companies in real estate, you know, I won't name any, but y'all know who they are, right? And that are promoting that fact. So interesting that we may be coming full circle.
And that, yes, you're right. And because of how the setup is taking place, you do have big tech companies that are saying essentially that they are planning for a world where that it could be the case because of these lawsuits. So this is the dilemma, and this is the unfortunate part when the government gets in. So the Department of Justice has been investigating this for a very long time, since the 90s, honestly, mid 2000s. They've been looking at this structure because what has happened was it has essentially put the sellers into a position where they are paying for representation of their opposition in the transaction, their opposition being the buyer, right? The buyer's interest is to buy the property for as little money as possible, and the seller's interest is to sell it for as high. Well, what happened? So this gave rise to the Sitzer-Burnett. And that's the primary lawsuit that I'm going to be talking about here.
Right.
There are a number. There's over 20 throughout the nation. But the Sitzer-Burnett was the one that really kicked things off 2019, which basically the class is from anybody who sold in mid 2014 who sold a property. So it's only sellers. And it was in Missouri. So Illinois, Missouri, that federal district. It's only for that jurisdiction. About 500,000 at the end of it, 500,000 sellers entered the class. So that's a lot of sellers, which is partly why the damages are so high.
Right.
Well, and what they argued, and everyone, by the way, so the jury, let me just take a step back here. The jury could not be a member of that class. So in other words, they could not have sold a property or even purchased a property in this time period. Because we don't want them to be biased in the transaction, right? But every seller had an agreement, an engagement agreement with their listing broker. It was all signed. And that, I think, is important because in Georgia, from buyers and sellers, we've had these agreements, right? But it is not because they did not have a signed, agreed upon agreement with the broker that stipulated what the commission is going to be. The case essentially came down to a number of factors. The lawsuit essentially came down to this. The seller must pay a buyer's agent when listing on an MLS. They must disclose what that commission is going to be. And it could not be zero. Now, that did later change. The National Association of Realtors did change that after the lawsuit, of course. But it could not be zero. So that's an important one. It's called a compensation rule. Yeah. The court case calls it the adverse compensation rule. The cases call it different things, but this was really one of the key points of this is that in order to sell your property as a seller, you would have to, well, have to is probably not the right word. In order to sell, it was very important to put it on a multiple listing service. That is how primarily deals are done.
Yeah. That's
And
how you get the
MLS
maximum exposure, right?
Exactly.
And it certainly sounds like if you can't put zero on what you're willing to pay a buyer's agent commission, then it's not as negotiable, maybe, right?
Correct.
And that's the argument. That's why.
Correct. Yes. And actually, the year before the Sitzer-Burnett case was filed, the Department of Justice had a workshop with the Federal Trade Commission and a number of international brokers that had brokerages in different countries, economists. And in that workshop, it really came out the direction that the Department of Justice and the Federal Trade Commission were looking at this. And it was really, okay, the landscape is set, right? There are, MLSs is pretty much how Zillow, Redfin, all these other companies pull their data to show the consumer. So consumers do see it. In order to be on an MLS, the MLSs had to follow, not all of them, not exclusive, but most had to follow National Association of Realtors handbook for MLSs. And that handbook told the MLSs that you had to reflect the offer of compensation from listing broker to buyer broker. What came out in the case as well, and in the workshop, is that the local MLSs are owned very frequently by realtor associations in the states. So you had NAR setting rules. You had MLSs being created to follow the rules, MLSs being owned by local realtor associations. So that created this dynamic of the same people are setting the rules are also the ones receiving the compensation. And that does not look good to Department of Justice, Federal Trade Commission when it comes to an antitrust investigation, right? And so so in that workshop, they had a number of testimonies. Some testimony from economists showed that when they had the exact same property, they did studies and examples of this, where they had one property listed, same property, they saw how much attention it received. They had the exact same property listed with 3% commission, whereas the first one had, say, a 1% commission. Well, guess which property had all the attention? The one with the 3% commission. So you could hear the arguments of steering coming in, right?
Yeah, but it was cleaner. It showed better. The pictures were professional.
That's right. That was not discussed.
Okay.
No, it was the same property. Well, the argument is it's hard to prove steering, but that was one of the methodologies they were looking at to say, well, hey, if you have this one property that's the same property as another, with just different commissions being offered, why is the one with more commission being shown? The Department of Justice has also instituted, it's called a civil investigation demand, where essentially they're asking brokerages that use core logic matrix, essentially the MLS to filter MLS. Mm-hmm. They're asking them for the data to show which brokers filtered by commission. Apparently you can do that. I didn't know that.
Wow.
So all these brokers that had filtered through the course of years, why would you filter by commission is the question.
Interesting.
So, it's not a discovery. It's not a subpoena. It's kind of a lower level. So it's called a CID. It's basically, hey, let us see that information. So you know where they're going, why they're looking at this.
Core Logic is the parent company, Mike, Broker Metrics.
Correct.
Right.
Yes.
Yeah.
And so that's where the government is looking and asking for this data. So if you happen to be an agent or a broker that has used that functionality, it could be captured in this investigation.
Interesting.
A lot of data.
Yes, that data. And also, as a quick aside, we're talking about the cases that are a civil case against the brokers and National Association of Realtors. Antitrust is also a criminal case. It can also be criminal charges filed. So now there's been no discussion of criminality yet, but what has happened is the Department of Justice has won an appeal to allow them to continue to investigate the National Association of Realtors and the brokerages for these claims. So we're only really talking about the civil right now, but it is certainly possible if they do find there to be criminal liability to pursue criminal cases.
Well, let's move on so we don't start anything there on the criminal.
Yeah, right.
Well, so I'm curious then, Mike, you're probably wondering the same thing, but why settle? You've got, I'm seeing, all these brokerages that were sued, and of course, NAR that was sued. It seems like, just from my layman's perspective, there wasn't much of a fight or pushback. So what happened? Why did they settle on these cases?
Right. Well, I'll speak on that. One last item I do briefly have to mention on the case. One of the rules that National Association of Realtors has for all realtors is when representing a buyer, you cannot submit an offer contingent on the seller's lowering compensation to the buyer's broker. Basically, what it means is if I'm a buyer and I'm negotiating with my agent, I can't ask my agent to submit an offer to a seller contingent on my buyer's agent receiving a smaller commission, which means the seller could pocket more money. You can't do that, or you couldn't do that, right? So that was another key point that I do have to at least come across. That essentially, I could not negotiate with my agent as a buyer. The seller set my agent's commission, and that did not sit pretty with the government as well. So I have to say that because that I think is very important moving forward on how commissions are going to be negotiated, I think, moving forward. To your question, John, on why the settlements took place. So essentially right now, if you were to total the dollar figure of all the settlements, it's about $942 million of actual settlement, undisputed. So, you have almost a $1.8 billion judgment. The defendants have settled for half of that right now. So they are paying a really big chunk of what that damages was. Now the damages could have been trebled to over $5 billion. So that could be one argument as to why a settlement may have been prudent at this point. But what's important too to understand is from the legal side of it, in order to appeal a federal judgment, you have to post a bond. And when you post that bond, you have to show you have the assets to pay the judgment, right? So if it got trebled to $5.4 billion, there's not many. But the NAR, I don't know their books, but I doubt they had that money. I doubt Home Services of America has that money. I mean, even though they're big company. So that has to play into the determination of this. Also, when you're looking at over 20 lawsuits nationwide, you're talking about legal defending those cases legally in all of that. So there are legal fees involved in every one. So that's from a kind of a high level looking at it from a monetary standpoint. Now, there has been some that have asked, well, why couldn't NAR just file bankruptcy, Chapter 11? I mean, they could have done that. Again, I'm not in the board meetings. I don't know what went in those discussions to decide to just settle it. But that was a possibility. It would have they've been able to restructure their debt if they did Chapter 11, and as well as the judgment. So it does speak, I think, to where the National Association of Realtors see these cases going and the likelihood of succeeding on an appeal. My thought on it is they did the analysis and they felt the risk that they would lose on appeal was just too great because of these arguments being made and that have been made by the plaintiffs in this case and in many of these cases were convincing for this jury in Missouri, and I think very potentially convincing for other juries as well.
Interesting. So what is, I know, speaking of myth understandings and, the speculation that's out there, the uncertainty right now is, I know, keeping me up at night in regards to like what's going on with the commissions and how do we react as an agent. But maybe start, what is the actual settlement? Like what's certain in the settlement for us as a real estate community? And then let's talk about maybe some of the unforeseen externalities of, what's to come, right?
Sure. So the settlement that is going to set the tone here is the NAR settlement. The other settlements are for monetary damages.
Okay.
So the Keller Williams, Compass, Anywhere Realty. So that's adding into the pot of damages. But the NAR settlement is the one that's going to set the tone for the rules that will be changed. And so essentially that NAR settlement affects about over 1 million members, nationwide NAR membership, officers, directors, other participants in NAR activities. There is a carve out for any brokerage that did $2 billion annual in volume over the course of 4 years. So if they average it out and it was $2 billion or more, they are not covered by this settlement. Now, unless they're, of course, a named party like Keller Williams or Home Services of America. So there are a number. I mean, it's not a large number, but there are those that are pretty big that are not covered. And so in the settlement, NAR negotiated to allow a mediation process rather than having to go to court and defend themselves. Any broker that is not covered by the settlement can go to mediation with the plaintiff's attorneys and come up with a settlement that would work for them. So just need to say that is potentially out there. The settlement goes into effect. Well, it was listed to go in effect in July, but actually it's August 17th is when the final class notice will go out to the class, the plaintiffs. And so that's the date that NAR has set to actually have all implementation of the MLS rules and changes go into effect. So keep that in mind that by August 17th, that's, nationwide, the changes would need to be made. Now, I do have to also say that this has been granted preliminary approval, but not final approval. So the final approval set by the court, I think, is in November. It could move, but the court will render an opinion on this settlement after the changes come into effect. So it's kind of a little odd, because if NAR makes these changes and the court decides, you know what, we don't think this is good enough, well, they're kind of back to the drawing board then with the plaintiff's attorneys. Part of this may hinge on the fact that the Department of Justice has not yet, they may not, but they have not yet issued a statement of interest in this case. They did it in another case, the No Select case. The Department of Justice, because of this recent winning of their appeal to continue to investigate NAR, that's why they're late to the game in bringing a statement to the Sitzer-Burnett case. So they may. I don't know if they will. I think they will. But depending on what they say, it will kind of, see what the federal government's position on the settlement's going to be. So I'm looking forward to that, to see if they do file that. So that could be convincing to the judge as well, to see if this settlement that I'm going to get into in a minute is sufficient for the country. So NAR settlement, essentially $418 million to be paid over 4 years. So NAR has, quite a sizable number of people who are a member, and they came out in the Sitzer-Burnett, they make almost $270 million a year in their dues. So I would think NAR would have the money and funds to pay this over a 4-year period. Yeah. So that's important to know. The NAR settlement covers these cases where it's the sellers bringing the case against the defendants. Does not yet cover any plaintiffs that are buyers. So there's a case in Chicago that buyers have brought. I don't think the grounds that it has is as strong as the Sitzer-Burnett, but the National Association of Realtors is pushing to have it encompass that as well. But that is not the case at this time. So there are still other cases out there. And actually, another very brief aside, the Home Services of America settlement only covers Home Services of America, not Berkshire Hathaway. So there is still claims against Berkshire Hathaway that is still continuing. So just as a brief aside. So I think the highlights of the NAR settlement are going to be, like we said before, no offer of compensation on an MLS, no more unilateral offers. Essentially, that has to be gone. Now, how that's going to take effect in practice, you can still, as a seller, offer concessions. So what if a seller says seller concession $10,000? Well, what's the buyer going to use that for? Well, they could use it for commission if they want. It won't necessarily specify that, but you can't say for commission, right? You can't say for buyer's broker commission. That's what's going to be done, but you can still offer concessions.
That's helpful to know. That's a really good takeaway because, at that point, it's still negotiable for more, right? I'm offering 10, but you could take 20 in concessions, right? And then how you choose to use that is really up to you. Yeah. So that's helpful to know. That's a really good point. All right.
And as a buyer's agent, you should just be mindful that you need to ensure you are putting in your offers those concessions. It's not going to be, just left to the instruction to closing attorney anymore after. Like you got to make sure if this is how everything's going to play out, that you get that in that contract.
Yeah, the
else
who, the what, the when, the why of the
Yes,
stipulation,
yes.
right? If you don't put it in the contract just because I offered it, doesn't mean you
Yes,
get it.
so you got to be careful with that.
Yeah.
And so another carve out again, if the settlement goes through in its entirety, there is nothing preventing a listing broker to post this same data, the listing data, on their own proprietary service that will show offers of compensation. Again, this is only for the multiple listing services. So keep in mind that if that remains as a carve out, I would not be surprised to see attempts to indicate to an outside MLS source for the offer of commission.
Okay, so if I'm Mike and I'm putting on my listing hat, then what I'm hearing you say is somehow in advertising, I could post that what I'm offering to a potential buyer's agent on my own website or something. Okay, just as long as it's not the MLS, and that's how it stands right now.
Mm-hmm.
But who knows where we
Correct. Yeah. Well, and this is one area where I would not be surprised if the Department of Justice, if they do release a statement of interest, tries to get rid of that carve out. Because again, we have to understand the whole point of why the Department of Justice is in this to begin with is because they do not like that cooperative commission. That's what they're trying to get rid of, right? In New York, the Real Estate New York Commission, it's just New York City, but that is now a practice where you can no longer in New York City as a listing broker share any commission with a buyer's broker. It must be negotiated in contract. So that is one city. Now, they weren't typically NAR members anyways in New York City, but this may be indicative of how this whole thing plays out. I would not be surprised if the Department of Justice, the federal government, this court, potentially the judge in the court, essentially just tries to get rid of or to set the stage to get rid of that entirely, where a listing broker cannot share. So when you're looking at right now, Georgia, the board in Georgia, on the forms committee are looking at our forms now and how best to convey to sellers that it is negotiable and you don't have to share anything with a buyer's agent, even like whether or not it's going to be listed on an MLS. So that they're working right now on disclosures to do that in the agreements. So that's a big one. I think that's probably the biggest change. I know there's been
timeline on that change. I know currently as it stands, you said mid-August.
Yes.
Okay.
Yes. And it may come sooner in Georgia, but the deadline is August 17th.
Okay, gotcha. Yeah. Deadline is August 17th. Could happen sooner.
Correct.
But we'll know, bottom line, we'll know through the GAR, not only when those changes are taking place, when they go into effect, but also when or how to respond based on our forms.
Correct. Yes.
Yeah. Okay.
Even an agent showing their value, no matter what side you're on, it's more important than ever right now.
Yeah, that's the big headlines, right? That we're seeing. Yeah, the headlines of I think I read somewhere Gary Keller said recently, show your value or get out, right?
Yeah.
And he's right, and that's always been the case. I think more so. Mike, you and I have been in the game a long time. I remember when I was actually selling real estate in the early 2000s, buyer consultations were a standard.
Mm-hmm.
They weren't optional. You had to get in front of them because Zillow and some of those companies, they didn't have access to the MLS at that point. And so it was a little bit easier to demonstrate value. And yet it was a standard to have that consultation. So I do think that, and we can talk about this in a second, Joel, but I do think there's you better know how to explain your value on the buyer's agent side and the listing agent side. And I think we've gotten away from that as an industry, and that's going to be trouble for some, for sure.
Where I have seen with some of my clients kind of falling into this trap. So yes, Georgia has had, and thankfully has had, a standard buyer engagement agreement with their broker that was very typical and pushed by brokers to be signed before representing a buyer, showing buyers properties. Now, it wasn't always, but I think where this kind of gets a little bit into the uncertain area here is it was a practice, and it actually was actually kind of an encouraged practice under NAR ethic rules to allow the agent or broker to tell the client, the buyer, that their service is free because the seller would be paying it.
I've certainly had that conversation. I'm guilty of having that conversation.
Long time ago.
Yeah, well, I mean, before 2022, that was almost encouraged, right? Because yes, you can get that buyer engagement agreement, but if you're telling the buyer that that they won't have to pay your fee, well, then the buyer's like, wow, I get free representation. Well, why not? Well, so okay, that in 2022, due to a settlement agreement that NAR had with the Department of Justice prior under the Trump administration, they had to change that, and they did. So essentially, no longer, unless your service is legitimately free, where you're not going to get compensation from any source,
correct,
you cannot tell the buyer that your service is free. You have to tell them that they are on the hook to pay that commission. Now, whether or not this,
Well, no, I was just going to add, in the buyer, one thing I love about the GAR and the Forms Committee in Georgia specifically is that the buyer's brokerage agreement is very clearly written to where it spells out like, hey, the listing agent may be offering a commission to me, and if they don't pay me, here's what you can expect, right? And then it's still, again, at that point, negotiable. So
I've had a broker tell me they tell their buyers that it will be free even if the seller does not pay. So essentially, they would say a seller's going to pay us, but if they don't, or if they don't get us our full commission, then buyer, you don't pay the difference, or you don't pay anything. So it is that, and that is actually one of the other parts of the settlement that I'll speak on now. So essentially, whatever you agree to in that engagement, number one, you have to come now nationwide. So there are other states, this was not a common practice to get a buyer engagement agreement. But every state, before you show a house to a buyer, if you intend on getting a commission, if you intend on getting paid anything, you have to get them to sign that engagement agreement. Okay. So this is, I think, going to be one of a bigger change than what we may initially think on first impression, because I know a lot of clients, a lot of agents would start showing houses, and then maybe, closer to closing time, or, then they'll get the buyer to sign that agreement. No, you have to get it done before you show the buyer their first house.
So let me ask a question on that, because this is what, that has been interpreted, because that law has already been in place. If you're going to advise someone as a client, then you have to have a buyer's brokerage agreement, right? Mm-hmm. And that obviously spells out the terms of commissions and how that's paid, et cetera, et cetera. And that's been in place for a while. Okay. And to your point, what ultimately ends up happening, especially with companies like Zillow now, where they're controlling the lead flow and the lead source, is that you have, Joel, we call them, and you probably heard this term, but we call them in the real estate business, Pop-Tart realtors, right? Mm-hmm. They just, the phone rings, boom, they pop up. I'll meet you at the house. What time is good? And Zillow's made that super convenient for the consumer, which is great. And so I'm curious, because you hear on one side of the spectrum, you hear companies maybe like a Zillow that's going, hey, buyer's agency is going to go away. And then, from the real estate perspective on the other end, from real estate companies, you hear show your value, show your value. So where is, and maybe there's no meet in the middle place on that, because if you're willing to be the Pop-Tart realtor and just go and show the house, it's at your own risk, right? Mm-hmm. I mean, and it sounds like, I don't know who's policing it, but potentially if you don't get a commission agreement signed and then take a commission, then that potentially could lead to some sort of penalty. I don't know what that is.
Yes. Yeah, it would be the local boards, commissions.
So that's a little bit uncertain and certainly new and different. And I'm wondering how that affects, and I don't expect you to have the answers to this, but it is part of the confusion as to what's coming.
Yeah. Well,
what happens to Zillow, and what happens to who is policing that?
Well, I want to add
the broker would be responsible, but I wonder who's policing it,
I want to add something you just said about Pop-Tarts. So one of the things that's great about the real estate business is if you are able to pass an exam, you can have a great career if you put the work in, right?
Yeah.
And it's just like, unfortunately, idiots and experts in this profession get paid the same in some cases. And so what I'm getting at is if you're on a football team and you're not cutting the mustard and you're not putting in the work, you're not doing that, you don't play. But here you can. And what I think every realtor out there should know, if you are someone who has been doing this for not a long time, or you haven't been really getting the buyer's brokerage or having consultations, you need to up your game and you need to learn how to do this and do it at the highest level. I know, and John and Joel, you do too. I know hundreds of people that are elite buyers and seller agents in Atlanta. And if you are that person and you're putting the time in your craft, you're not going to have a big problem about articulating your value. It's the ones that the Pop-Tart that doesn't spending time working on themselves going to have a problem.
Yeah. So Joel, go back to what is the actual, result of the settlement that a buyer's agent has to do to follow, the guidelines. Like what they have to get a buyer's brokerage agreement signed.
Yes.
And
the negotiated commission in that agreement is what you will receive as a buyer broker or the buyer's agent. So that you can't make it contingent on an open commission structure, i.e., whatever seller agrees to pay. You can't do that. So
Joel, you're my client. I'm working with you. I sit down and demonstrate my value. You're agreeing to pay me 11% commission.
Yeah.
Right? I mean, that's negotiable.
It's negotiable, yes.
So if I demonstrate the value and can convince you to sign that, that would be what I would be due. Now, correct. I could also say 8. I could say 2. I could say 1, whatever, right?
Mm-hmm.
So here's a good question. What if I get to the actual property and I show it and I've negotiated my commission on this buyer brokerage agreement with the buyer ahead of time, like I'm supposed to do? Well, I find out that the seller is actually offering more than what I negotiated. How does that work?
Well, you would not automatically get access to that money. You would have to have an agreement with the buyer for the buyer to agree to increase the commission structure for you to receive whatever the sellers agreed to pay. And that sounds easy enough. It sounds like, well, why wouldn't the buyer agree to that? But I can envision a world where more and more, if this gets more information out there, buyers and sellers are reading about commissions and more just transparency, that buyers may say, well, maybe I don't want you to get that extra 1.5%. Maybe I would prefer to negotiate with the seller to get that on a reduction or some concession. Yeah. Why the buyer certainly can do that. So again, to Mike's point, the expectation is that as their representative, you would have shown your value to be certainly worth that extra 1 to 1.5% when it came down to it. But the buyers, you need to convince them of that. Yeah. And so I like that example because it's not a done deal exactly what's going to happen with that extra. So let's take that same example. Well, what if it's a seller agreed to pay 3 in their listing engagement, in their listing agreement with their broker? Buyers only agreed to pay 2 to their buyers. So there's an extra 1% sitting out there. Well, who gets that? Right. Mm-hmm. So it's going to come down to, well, how is the listing commission structure negotiated? If it's negotiated where listing broker receives 6% and pays 3 to buyer, well, if buyer's only getting 2, well, the listing broker is going to get that extra 1. If the listing agreement's negotiated where 3 and 3, well, then now there's the listing won't be entitled to that extra 1%. So
yeah. It's interesting. I think it's going to be a little bit like the Wild Wild West for a time.
Yeah.
Mm-hmm. Until we sort of land on what the new normal is. But I do think, and let's talk about that. That's a good segue. What, Mike, and maybe you could answer this as well, if not better than Joel, but what are some of the unforeseen, externalities that you're already hearing and or concerned about?
I'm going on.
Mike, you didn't say this in the beginning. Mike does over $50 million a year with his team. I think, Mike, maybe more. But yeah. So you're out there. You're out there working and hearing
every day. Yeah. We're going on listing appointments, not just me, my team, but I've probably been on 10 listing appointments in the past 2 weeks. And I'm talking about, I'm walking into situation where sellers are going, hey, I've been watching this thing on the news. Looks like I don't have to pay the buyer's commission. I'm going to go pay you X now. And the buyer agent needs to figure it out on their end. And then we have to have the conversation. Okay, that sounds great, but you want to get the most eyeballs on it. And there's going to be some buyers that can't afford to cover the difference because they're putting every dime in. Like when you bought this house that I sold you 3 years ago, you were strapped. You put everything into it. So that's one thing that's coming into play. That's going to be hard to overcome. Now, as a listing agent, I've always negotiated as much commission as possible and always been fair and split it with the other side. Always, no matter what it is, 3, 4, 5, 6, it doesn't matter. But it's going to be, if you're a listing agent now, I mean, you almost have an advantage because what you've already been getting 3, 4, 5, 6% for the last few years. You could technically command that still commission for what you do because you've always been the one getting paid. Now, the problem is going to be if you're a buyer's agent and you haven't been articulating that, it's going to be hard. So, I mean, I guess to kind of put a bow on it, I mean, it's going to be the Wild West, John. It's there's every meeting is different there. Some will pay it, some will pay a little bit, some don't want to pay it at all.
Yeah, well, so Mike, let's say you come to my house, we're sitting at the kitchen table, right now I'm reading these headlines, commissions going away, So you sit down, you're like, hey, I'm ready. This is what I would do to sell your house. And I go, hey, Mike, so I'm understanding now I don't have to pay a buyer's agent commission, right? And what is your response? Like, give us a little taste of, because I know you've already had those conversations.
Oh yeah, I'll say with John, that's a great question. In reality, you've never had to pay a buyer's agent commission ever. You've always paid the listing agent, and the listing agent, the strong listing agents, agree to share some of their commission because this whole setup is based on cooperation, and we want as many people as possible walking through your door. And you definitely, in most cases, want somebody that's being represented by a professional realtor, because it can be all kinds of issues if it's just somebody off the street that has never bought a home. There's a lot of things that go wrong. So you definitely want, just like you're getting representation, you want the buyer to have representation. And no, you still don't have to offer any compensation. However, as this develops in the next 3 or 4, 5, 6 months, you would possibly get lower showings because some buyers may not even want to do it without an agent if they can't afford it. So there's a lot of different things that we have to think about.
Yeah, and I think you make a really good point, in regards to the buyer having representation and allowing, that opportunity for them. Isn't it true that someone that's coming in without representation would be, I think, more likely to get spooked or lost in the transaction, which could be, overwhelming for them and cause them to back out. So maybe we get down the road and now they're backing out. Maybe it's within a due diligence period. Maybe it's not. But even if it's not, during the due diligence period and they just basically breach contract, you've still got to fight to get that earnest money. And what does that look like? And, are they depositing the earnest money on time? Like, and who's managing that? Right. There's a lot of unforeseen, externalities that people just, we don't know. And that's the confusing part. Like, we don't know what's going to, Mike, you and I were talking about the other day, like if Zillow and some of these companies that are predicting buyer's agency goes away, which I don't know that they're not right, because you've got down payment and closing costs on the loan, right? Which you're going to have as a buyer. Well, there's only one thing that I can cut, and that'd be buyer's agency commission. So as a listing agent, Mike, how do you prepare for, what are you thinking about when a buyer calls you from your sign and says, hey, I'm at your listing, I'd like to see it?
We've done it in the past, and I've worked with buyers that don't have agents, and some have gone well, some have not. And they're a customer, they're not my client. And so it's limited what I can do for them. And I tell them on the front end, hey, listen, you're a customer. I can provide you with, some data on the market, and you can but I can't really give you any kind of, I can't be your guiding light because I work for the seller. And a buyer in any market that doesn't think that they need representation is, and I'm going to probably get mad, people get mad, it's kind of foolish for not working with a pro. I mean, I wouldn't try to do a closing without an attorney like Joel. I mean, there's no way. Why would you want to buy a $500,000 asset without somebody that's done it 1,000 times that can help you? And so there's going to be a lot of agents, I think, that are a lot of buyers that will come straight to the listing agent. And I think it's going to get a little messy, honestly.
It's going to be it's going to be messy for a time. I do think, and Joel, you tell me if I'm wrong, but I think we'll figure it out as an industry, sooner rather than later. But I think there's going to be a time period, and maybe some people, there's going to be some casualties along the way. There's going to be some agents that aren't, strong enough to figure it out. So I think the message here to our real estate friends out there is make sure that you're a part of a really good team, a good brokerage where you're getting updated information. Go find your local attorney. If you don't have an attorney, call Joel, right? I mean, call Joel and figure out, or email Joel and figure out a time maybe to go to lunch with him and ask questions and that sort of thing. This is a live stream. I don't even know. I can't even tell Mike how many people we have viewing.
We have 14 viewing right this second.
Yeah. So, and I don't know, is there questions on the back end, or do we want to take a minute? I know we're getting up close to time and I want to be respectful of Joel's time.
Yeah. I don't see any questions. If you guys have any questions, go ahead and put it in the comments on the Facebook page.
If I could briefly talk on a few points. Mentioned here. So, I think you guys are hitting the nail on the head on the pressures that are going to be put on the listing side as well. While the lawsuits are, seem to be and are primarily focused on the buyer's representation, on the buyer's agent and that agreement, there's going to be a lot of that pressure on the listing agents. Just like you said, Mike, you may be called more to go show a house. And by the way, if you do, you don't need to get that engagement agreement with the buyer before open the door, right? Because you're not going to be their agent. So just as a quick aside, you don't need to, in that instance, do that because you're not going to be representing them. So that wouldn't be covered under the requirement to get a signed agreement before opening the door.
Well, real quick, let me touch on that. So if you're a listing agent out there and you get 5 or 10 or 12 calls from people that are not represented, you don't have to pop up and leave dinner every time we go do it. You can set up between 2 and 4 on Saturday.
Yeah, it becomes your new open house,
and the serious buyers will show up.
Yeah, it becomes your new open house. Maybe it's a weekly, open door policy or something.
Exactly.
Yeah. And so keep that, and there could be business opportunity there. Exactly right. So I've talked to some clients, brokers that are actively looking at how they do structure more appointments to open doors for unrepresented buyers. I don't think that would be a bad strategy to see, okay, well, how can you capitalize on that then? Right? Totally.
Yeah. So there's a positive right there. I like that. Yeah, that's really good.
We do have a question. We just answered it, but it said if someone comes to your open house if someone comes to your open house unrepresented, do they need to sign a VBA with the open house agent?
No, unrepresented unless that agent. No, because if the agent's working for the listing broker, no.
Okay.
No, you don't need it. And actually, I will keep in mind, Zillow has come out with, I don't know if you all seen this, their kind of temporary engagement agreement that they made accessible to everybody. It's essentially just a few days where the agent could get the buyer to sign it to kind of be covered under this agreement, under the settlement here. So the engagement's only a very short period of time. So there are actively, agreements coming out now, and it's available now if you looked it up.
I would bet that GAR comes out with something like that too.
Oh yeah, definitely. And speaking on that,
Joel, let me ask one follow-up question to that, because this may be what the agent was asking. So if I'm representing the listing, the seller, I don't need to have that BBA signed. But what about if I'm a buyer's agent, unaffiliated with the team, same brokerage, that is just trying to pick up business or opportunity?
Yeah, then you would want. Yeah,
if you would have to sign this potentially temporary BBA.
Right.
Sign a one-day BBA.
Yeah, right. Now it's arguable. I think the Virginia Association of Realtors are saying that Zillow one may not be legal. So, I mean, again, use anything that's coming out now. I mean, we're testing it. Just like you guys were saying, this is going to be a little messy. We're going to see creative, innovative things coming out of this in an attempt to find that right middle ground of, being able to have the transparency required by the settlement, but also capitalize on a marketplace that will be shaken up. I mean, some experts are thinking 30% of agents, will drop out because of this. Which means more business, right? I mean,
disclaimer too on any of this stuff that we're discussing. Obviously, this is subject to change. And we should say too, Mike, consult with your broker. Like, figure out
always, and your attorney.
Yep. That's the big thing. Make sure that you're being compliant, not only from an NAR standpoint, but also within the terms of what your office has agreed to do. So. Yeah.
When it comes to the buyer's commission, I do know the forms committee are considering ways to have provisions baked into the buyer engagement agreement that will allow pre-negotiated amounts. So, like, in other words, the buyer's broker is entitled to this amount, but if seller is offering more, can it be pre-negotiated with the buyer for the buyer to already have agreed for the buyer's agent to get that increased amount? That's going to be tricky, and I would not be surprised to see something like that in a more recent amended engagement agreement. It will be used probably if it's there, and we'll see the legality of it. But they're actively now looking at ways to try to capture as much of this as possible.
It's not going to be business as usual, but it's still going to be business. And I'm going to urge all realtors out there, if you are panicking about what's coming up, just like John Fountain just said, get with your broker, get with the team leader in your office.
Yeah.
Talk to the top producer in your office, get in a mastermind, like get involved and learn, what you need to do, best practices, and then just get out there and execute, and then you're going to be fine.
Yeah. Collectively on this call between the three of us, we've got, I'm sure, 40 plus years of experience. I can remember when, and everybody talks about this, but remember when it was just like a MLS book, right? And then it went online, and that freaked everybody out. And it was probably chaotic for a little while. That was right before I got in. And then the internet happened, and we put everything online, right? And it was dial-up internet. And then Zillow happened. These are some of the major changes that I can remember in my career. And for a time, it's unsettling. We're still angry at Zillow, right? To some extent.
Yeah.
So it's going to be different. A good book I would recommend is Who Moved My Cheese, right? Go read that and figure out, like, instead of being him and haw, how do I move forward here and find the cheese? Yeah. And once we do that collectively as the industry, and the great news, and Joel, I love that you said this, and you opened my eyes to this in our conversations, not only today, but the other day. The GAR is our friend, and we've got some amazing people on the forms committee that are, helping us, maneuver through this as it changes. And then the other thing I'll say, and guys, back me up on this, I think we're going to plan on doing this again. Like, we'll do this again in a month or so and continue the conversation and have some different faces on here at times and get some different perspectives. And, it's great. And Joel, give us some parting thoughts. What did we not talk about that you wanted to tell everybody? And then let's wrap it up to be respectful of Joel's time, Mike.
One thing I don't think I got to when talking about concessions from the seller, Fannie and Freddie recently announced that would not count towards the agreed upon or the regulated maximum concession allowed by a seller. In other words, so if in negotiations you're able to represent your buyer and you get the seller to agree to pay a 3% commission, then that won't count towards the maximum of, say, 3% in a conventional or 6% in an FHA loan. So it's good to keep in mind, because that was an outstanding question until the Fannie and Freddie came out with that. So that's we at least know that's not a hurdle that we'll have to address.
That's good.
Yeah, I think there's a question on the touring agreement. It's a temporary, it does not cover commissions. The Zillow touring agreement, it's only a temporary 7-day, only meant to cover the activity of touring and showing the property to a buyer. It's kind of meant to be that baby step before getting an actual engagement agreement that does specify the terms of representation.
Prove the value.
Yes, right. Prove the value. Then finally, there are special stipulations under the standard GAR special stips, 619 and 620. that specify seller agreed upon commission to be paid to buyer's broker. So take a look at those 619 and 620. It's already there. And again, whenever the amended documents come out from the forms committee this year, they may bake something into the purchase and sale, perhaps. I'm not sure, but for now, you can look at those.
Joel, I'm sure, most people probably know you, at least in the Atlanta market, but if someone wanted to connect with you or reach out, how can they find you?
Sure. Just look up Pacific Law Group. I'm in the Alfred office. My email is joel@pacificlawllc.com. We'll be happy to take care of you. And or if you have any questions, again, if you're an agent that wants to talk more about this, feel free to reach out. I'll be happy to talk to you about it.
And they're always welcome to send closings your way.
Oh, of course, yes. That's our bread and butter. I love doing it.
Exactly.
Joe, I'll put your email in the chat after this.
Thank you.
Well, guys, this has been. I'm shocked. Number one, that it's an hour already. This has been super fun. I want to do it again, Mike. So I want to say thank you for setting it up. This was your brainchild. You made it happen. Really cool. And want to thank everybody that joined us. And let's do it again. Joel, thanks again, man. Wealth of knowledge. Yes. I feel like we could go 2 more hours.
Oh, yes, I could. Thank
John,
you very
before
much.
we go, how can anybody that needs to get in touch with you about Homeward, which I highly recommend you guys calling John about that. What's the best way to get in touch with you?
Yep. My name, John, with a dot in the middle of it, John.Fountain, just like a water fountain, @homeward.com.
Got it.
And, man, this is good. We'll do it again. Thanks, guys.
All
Joel,
right.
thanks for your time, and we'll circle back to you later. John, thanks again for your time today. Thanks for making it happen today, gentlemen. Mike Price signed off. Commissions update. So what? Now what? Get in business with the best in your office. Find out what to do this. Call Joel if you have any attorney questions, and just be the best agent you can.
We learn from each other, so reach out, you guys.
Yeah, collaboration over competition. We're all in this together. No matter what brokerage you're with, we all got to help each other get through this.
Love it.
See ya. All right, thanks.
Thank you.